Hello, everybody, and welcome to Fair Use in RPGs. My name is Rob Hebert. I am a lawyer, game designer, artist, illustrator, working out here in California. I specialize in IP law for, I'm in-house counsel for an audio production company, but today I'll be talking about fair use in the role-playing game scene for publishers, for artists, for streamers, for reviewers, and I want to give a big thanks to Andy and Eric, who are helping out on the technology side of this panel. And what I want to start with is just discussing what fair use actually is. So before I really get into it, you can follow me on Twitter and Instagram and all that good stuff at Nerdy Paper Games. Sometimes I do threads about some of the legal implications of creators' rights and copyright and trademark in RPGs. That's also a good place to contact me if you have any questions after this thing is over. We will be taking questions at the end of the panel as well, or if you have anything that comes up during the panel that you need clarification on, I'll try to explain that in the moment. Just to give everybody the your standard disclaimer. I'm a lawyer, but I'm not your lawyer. All of this information is for educational purposes. If you rely on this information or your misunderstanding of it and you get in trouble, do not blame me. Not my fault. Your fault. I know that sounds kind of mean, but honestly, this stuff is easy. You'd be fine. But if you're concerned about actual legal implications of it, please find and hire a lawyer to go through that. That being said, fair use is a fairly simple concept as far as legal principles go. Fair use is an affirmative defense against copyright infringement. So what does that mean? We need to start with what an affirmative defense is, and then what copyright infringement is. So an affirmative defense is when you're saying that you did do the thing that you're in trouble for, but you can affirmatively defend yourself against that claim by showing that there is some sort of legal privilege or exception that you're using. So, for instance, probably the most classic example of an affirmative defense is self-defense, where you said, "Well, yes, I did kill that person, but it's not murder because I was acting in self-defense." There's something kind of similar with IP, where you're saying, "Yes, I did potentially infringe on someone's copyright or someone's trademark, but I have an affirmative defense against it. In this case, fair use." So what is copyright infringement? There was earlier today another panel about IP, intellectual property, and licensing in RPGs. I highly suggest that you watch that. There will be a time-shifted version of that available in perpetuity after today. But in short, intellectual property concerns copyright, trademark, and patent. And we don't have time to get into all the differences between those, but in general, the simple version is that copyright regards the stuff that you make as an author. So the pictures that you draw, the words that you write, the books that you create, etc. Trademarks are logos, names, logotypes that indicate the authorship of said material. So in copyright, for instance, the copyright for Dungeons and Dragons would be in the actual words in the books, the Dungeon Master's Guide, the Monster Manual, etc., the pictures contained therein. And then the trademark would be the name Dungeons and Dragons, as well as the logo. So where fair use comes in is if one were to make use of copyrighted material contained in the Dungeons and Dragons Dungeon Master's Guide, for instance, or if you were to use the trademark. Now, I've just used Dungeons and Dragons trademark under fair use because I'm referring to it as Dungeons and Dragons. There's a trademark in that name, but I am using it in order to identify the actual product itself. So that would be one of the exceptions under fair use, which we'll go into. So, so to understand what fair use is, you need to understand what the legal source of that doctrine is. Fair use comes out of common law, which is sort of prior to the rise of the legislative state and the various other ways that we in United States law determine what the tests and balancing factors are for things like copyright. Fair use comes out of that common law tradition, but it has been crystallized by 17 United States Code Section 107, which puts forth 4 different factors for determining whether something is fair use. So we facially infringe upon copyright and trademark all the time. We do it whenever we copy passages from books, we photocopy character sheets, we do lots of things. Playing a game at all, we are facially infringing copyright. But we're not susceptible to the money that you would owe under certain statutory damages. You can't be subject to an injunction against using copyrighted material and trademarks under the fair use doctrine. So the fair use doctrine covers 4 factors, technically. There are actually some extra factors that we'll go into, but in its simplest form, fair use covers 4 different factors. There is the purpose and character of the use, which is the most important. There is the nature of the copyrighted work, so the work that you are ostensibly infringing. There is the amount and substantiality of the portion that has been taken, so the portion of the copyrighted work that is being used. And then there's the effect of the use upon the potential market. So these 4 factors are the elements of the test that if you were sued, for instance, for copyright infringement, and you brought up this affirmative defense of fair use in court, the judge would be looking at each of these factors independently and then weighing them against one another. Now, one of the things you often hear when people talk about fair use is that the test really isn't dispositive because anyone can that any individual case of fair use is not it's not actually fair use unless a judge deems that it is. And that's technically correct, although I think it overstates the difference between fair use and other legal doctrines, because really you can say that about a lot of things. You can say that it's not self-defense unless a judge says it is. But the fair use doctrine is pretty is pretty easy to apply in your own to your own situations and determine whether you would have a valid defense under it. So I'm going to go back through those 4 factors in the test. The first is, again, purpose and character of the use. And again, this is the most important. So if you ever end up in court, which you don't want to happen because that's pretty expensive and time consuming, but if you were to end up in court, this would be the one that the judge would take the closest look at. And that would be, what is the purpose of using this component, the component of copyrighted material. So let's say you were going to let's say you were a streamer and you were going to give a review of a new product from Wizards of the Coast, a new book, a new Dungeon Master's Guide or new edition of Dungeons and Dragons. Well, we look at the purpose and character of that use. The question would be, are you creating something new, or are you just copying verbatim from the underlying copyrighted material? In this case, if you were giving a review of this new book, then you would actually be creating something new. You'd be creating this review, would be relying upon the underlying material because you're reviewing and you're going to talk about it, you're going to give examples from the text. But and in that case, you are copying that portion verbatim, but you are creating something new with it. You are adding value to that by reviewing it. Second element in that would be, are you transforming the underlying copyrighted material by adding new expression or meaning? This is a little bit of a tricky element to this factor because some people consider it sort of a fifth factor, separate from purpose and character. Some judges, some court cases have used it as a sub-factor of this purpose and character factor. It doesn't really matter one way or the other. Whether you treat it as a sub-factor or its own factor, it's applied the same way in either case. The question is, are you adding new expression or meaning? In the example that we're using here, where somebody is giving a review about this new book, they are adding new expression and meaning to it because they are building out their own reactions and to the underlying copyrighted material. Is there value added? That's another subcategory or a subfactor here. Is there value added by creating new information, new aesthetics, new insights, or understanding? Obviously, in the case of a review, the purpose of a review is to give the listener or viewer a deeper understanding of the material being reviewed. It's also intended to give someone insight into the reviewer's reaction to the underlying material. So again, there's new information. There's probably new aesthetics because if you imagine that this is either a blog review, so it's written, or it's done on YouTube, or it's even done on Twitter, there is some creativity involved with writing and then communicating that information to the people reading or consuming the review. The classic examples of purpose and character reviews that you see come up time and time again in court cases and in law review articles about fair use are things such as parody, scholarship, research, and education. So those sorts of uses and purposes are going to more easily fall under fair use because those reflect the fundamental purpose of fair use, which is you don't want, as a society, we want copyright to exist. At least the theory is that we want it to exist so that it protects the interests of creators and authors. But we don't want to create a situation where that protection is so ironclad that it causes negative effects on society as a whole, where we can't, for instance, you can't talk about a movie because you'd be infringing on the copyright in that movie. So for things that are seen as socially desirable, such as scholarship, research, and education, fair use gives a helpful escape valve for uses that would otherwise infringe. Now, what are some examples of purposes or characters of use that are less protected? Anytime you're doing it to make money, that is seen as less socially useful. So therefore, this factor would not weigh as heavily in favor of the person claiming fair use. If you are attempting to obviously disparage the copyright holder in some way, that would not be seen as a valid purpose of the use. Obviously, because this is a balancing test, this first factor, purpose and character of use, is not entirely dispositive. So just because you are claiming that this is for educational purposes, that your use is for educational purposes, doesn't mean it's automatically under fair use. Just because it's a parody does not mean that it's automatically fair use, although parody is one of the stronger purposes in terms of protecting your fair use of copyrighted material. But that being said, this is the most important factor. So if you can show that the purpose of it was scholarship, research, education, or parody, that will heavily favor you. With the review, that's kind of an interesting case because you might be creating the review in order to sell advertising on it, or to promote your own work, or to bolster your YouTube channel. In that case, you are doing it for a commercial purpose, which would cut against this. But a review is it can be considered partially scholarship or education. So those are all elements that a judge will take into account when balancing out this initial most important factor, the purpose and character of use. The second factor in the four-factor fair use test under 17 USC 107 is the nature of the copyrighted work. This looks not at what you have created in your use of the copyrighted work, but it looks at the copyrighted work itself. The two biggest elements of this are, is the work factual or fictional? And is the work published or unpublished? So that first sub-element, fact or fiction, in a broader sense, what you want to think of is how imaginative or creative is the work. If someone publishes a timeline of events, say, to keep with our D&D example here, since it's a copyrighted work in a trademarked entity that most people are familiar with, if someone were to publish a timeline of the publication dates of the various editions of Dungeons and Dragons, as well as the splat books and manuals and so forth that came underneath that, that would be a actual work. There could be some creativity or imagination involved in either the research that led to the copyright holder having created that timeline. There might be an imaginative or creative way in which that timeline was published, and so they could be it could be an interesting visual method for conveying that information. But nonetheless, that would still be a factual work, and so there would be less. There would be less of an interest in maintaining the creator's rights in that case, which would mean that you have a better chance of asserting fair use over the use of the underlying copyrighted work. Where something is fictional, there is obviously more, or we assume that there's more imagination or creativity involved in its production. So there would be a greater copyright interest for the author of such a work, and therefore it will be more difficult to assert fair use in that instance. So while you might have a timeline of publications for Dungeons and Dragons, that would be a factual thing. If someone were to if someone were to discuss their interpretation or their interaction with those publications, and they were to, for instance, give almost an autobiographical perspective on the release of D&D editions and supplements throughout their life, obviously that would be imaginative and creative. That could even be considered a fictional work, because they're not merely reproducing facts and dates. They are writing down their experiences in that case. Another element that is relevant to RPGs and RPG publishing is a lot of RPGs will use factual information and then fictionalize it in the copyrighted works that get put out. So, for instance, a game or a source book that uses information about the American Revolutionary War will be reproducing facts, but they might decide that, okay, well, we're going to talk about these secret organizations that George Washington actually was a part of in real life, but we're going to add this fictional element where it's involved somehow with like the Lovecraftian Cthulhu mythos, right? You've seen games like this. Obviously, in those cases, there is a fictional, imaginative, creative element to it, where if you were to just reproduce that, the nature of the copyrighted work in that instance would cut against your claim of fair use. The other sub-element here is published versus unpublished works. So one of the things that copyright is meant to protect is there is a right to control the first public appearance of a work that you create. So if I write a novel, as the author, I have a bundle of copyright privileges and rights that are wrapped up in that, having created that. But one of them is that I get to decide who sees it and when and how, and that has to do with first publication. Because of that, if you utilize a portion of an unpublished work, that is seen as cutting against you in terms of the assertion of fair use. You are much more likely to prevail in an assertion of fair use if the underlying copyrighted work is something that is available to the public, because you are not infringing upon this underlying sub-right of controlling first public appearance. So to go back over that, the second factor here, first factor was purpose and character of use, which is the most important one. The second one is nature of copyrighted work. So that looks not at the actual way that you used it, but the nature of the underlying copyrighted work. And again, factual has less protection than fictional, easier to assert fair use over reproduction of facts, and it's easier to assert fair use over the reproduction or use of published work as opposed to unpublished work. The third factor is the amount and substantiality of the portion taken or the portion used. A lot of the language that you see in these court cases and in the legislation, they use taken and used sort of interchangeably sometimes, which is a little bit of a holdover of how copyright was thought of in the past. But generally, the amount and substantiality, of the copyrighted work that is used is a major factor in determining whether fair use is an appropriate defense. Generally, the less of the copyrighted material you use, the better your chances of asserting fair use, which makes sense. Obviously, if you reproduce the entirety of a book, you are infringing to a greater degree on the copyright holders' ability to determine how that text is used. And so, of course, using more means you are less likely to be able to assert fair use. That doesn't mean that just because you're using what you think is a small amount of the underlying work, or is relatively a small proportion of the work, doesn't mean that it's automatically fair use, because one of the other tine on the fork for amount and substantiality of the portion taken is whether or not you've taken the heart of the work. So a good way to think of this is am I using the most memorable piece or passage of the underlying work? These are sometimes referred to as quantity and quality. So quantity is it's easier to assert fair use over less rather than more. And the quality, which is it's easier to assert fair use over the less important portions of the work compared to the more important portions of the work. So what does that mean in terms of actual application in real life? The heart of the work is going to be the most memorable aspect of it. So if you were to use a song, for a portion of a song, for instance, using the hook or the chorus or the most famous line or the most important line, that is the heart of the work, as opposed to if you were to use a small portion of the bridge, let's say, or a turnabout in the musical composition. To use an example from the world of RPGs, if you were to use a portion of the if you were to use a portion of a character description, and it's like a minor NPC from a source book, well, obviously that is a small portion. So in terms of quantity, you have a better chance of asserting fair use, and also in terms of quality, you have a better chance of asserting fair use, because it'd be difficult to argue that the most important or most memorable part of a splat book was a portion of a description of an NPC. Contrast that with something like the elevator pitch core description of the world for a splat book, right? Where you get the cool how this world was created flavor text, the kind of thing that you would put on a Kickstarter to get people excited about backing it. Obviously, that is going to be much more the heart of the work in that instance. The fourth factor here for the fair use doctrine is the effect of your use upon the potential market for the copyrighted material. This is a little bit of a mouthful, but it's pretty easy to understand conceptually, even though sometimes applying it in practice can be a little bit tricky. The central question here is, does your use of the underlying copyrighted work deprive the copyright owner of income or undermine a new or potential market for copyrighted work? That new or potential market is where it gets a little bit tricky, but the basic premise here is pretty easy to understand. If I am reproducing a splat book, the text from a splat book in its entirety on my blog, and anybody in the world can just go to my blog and copy paste that or read it off of my blog instead of purchasing the splat book for their own use, obviously that has the potential to deprive the copyright owner of the income from that income from that sale of the splat book from the person who is just pulling that information, pulling that text off of my blog. The purpose of that new / potential market language in the legislation is that it's not always the case that a copyright owner is exploiting their copyrighted work in all the ways that they can, or that they intend to, or that they may even know about. So a good example of this might be if if someone were to take an image from a Dungeons and Dragons splat book, let's say of a Beholder, or let's not even use Beholder because that's a trademark. Let's use a werewolf. There's an image of a werewolf. Obviously, there is a copyright in the splat book of this werewolf. There in the image of this werewolf, this drawing. I couldn't take that image and then open up a Redbubble e-commerce site and sell T-shirts with that image on it, partially because I would be depriving the copyright owner of a potential market for that image, even if they don't sell T-shirts with that werewolf on it. The idea is that they could, at some future date, do such a thing. Same goes for any sort of merchandise, or if I were to use the copyrighted image in my own game, my own published materials, I am entering a market that Dungeons and Dragons, or Hasbro technically, could potentially move into. So when looking at whether you can make a claim for or assert fair use as a defense against copyright infringement, you want to look at not only are you potentially depriving a copyright owner of income in a market that they're actively taking part in, but are you planting your flag in a new market that they could conceivably go into had you not sort of poisoned the well by misusing their copyrighted material. So to go back through those four factors real quick, we have purpose and character of use, the most important one. And that asks us, that forces you to ask, are you creating something new, or are you copying it verbatim? Are you transforming the underlying copyrighted work by adding new expression or meaning? And is there value either in the work itself that you're producing or to society as a whole through the creation of new information, new aesthetics, new insights, or new understandings? And again, examples include parody, scholarship, research, education. Those are going to be your strongest claims for fair use. Second factor, nature of the copyrighted work. Is the copyrighted work factual or fictional? If it's factual, then you have a better claim for fair use. If it's fictional, you have a weaker claim for fair use. Is it published or is it unpublished? If it's published, you have a stronger case for fair use. If it's unpublished, you have a weaker case for fair use. Third factor, amount and substantiality of the portion taken. If you use less of it, stronger case for fair use. Use more of it, weaker case for fair use. And then also the qualitative element to that, which is, are you using the heart of the work? How important or how memorable is the piece or passage that you are using? If it's more important, more essential to the work, then you have a weaker case for fair use. If it's a less memorable or less integral element of the work, then you have a stronger fair use case. And then finally, effect on the use effect of the use upon the potential market. So, are you depriving the copyright owner of income or undermining their ability to generate revenue with the copyrighted work? If so, then you have a weaker case for fair use, and that applies to markets that the copyright owner is actively engaged in, and any potential or new markets that they could become engaged in. So those are the main four factors. And anytime you're looking to determine whether your potential use is going to be defensible under fair use doctrine, you want to look at those four factors and think of them like a judge. Imagine that you're the judge coming to this and looking at those four factors. The thing that makes this tricky is that because the fair use doctrine uses for factors, there are no bright lines here. There are no ways to point at something and say, oh, I used fewer than 10 words, or I used fewer than 10 seconds of this song, which you've seen something like that before, where people claim that because they've used fewer than 10 seconds, that they can't get a copyright claim. Not accurate. Those 10 seconds could be the most integral part of the song, and therefore you would fail this substantiality of the portion taken prong, and that could be enough in and of itself to make fair use inapplicable to your situation. In which case you could be liable for damages, or you could get an injunction against yourself. A good example of something like that would be, the one everybody talks about is the opening chords or the opening notes of Satisfaction by the Rolling Stones. It's easily the most, one of the most memorable parts of one of the most famous songs in the world. You could not copy that and use it for your own purposes unless some of these other factors weighed heavily in your favor. For instance, if you were making, if you're giving a review and if you're giving a review of the album and you used those opening notes in your review to help explain what your perspective was on it, or if you were giving a class on music theory, in that case, the purpose and character prong would weigh heavily in your favor because you'd be doing scholarship or education, and that could outweigh the substantiality of the portion taken prong. What are some other elements here that you want to keep in mind when determining whether your use of a piece of copyrighted material might fall under the fair use defense? There is something called the de minimis defense. This is sort of a supercharged version of the amount and substantiality prong of the test, the third prong. The de minimis just means you've used so little. De minimis defense just means you've used so little of the underlying copyrighted material, or you've infringed upon it to such a small degree that it's really not necessary to go through the full four-prong test. An example of this might be, for instance, right now behind me, Happy Halloween, everybody. There is a Rosemary's Baby poster. Obviously, there is a copyright in the poster itself. There is, and wrapped up in that is the ability to print new copies of it, make copies of it, to sell copies of it, to display copies of it, and so forth. Obviously, in this case, it being behind my head on a stream like this is a de minimis use of it. It's merely on my wall. I don't think that we could go through the four factors, obviously, and we could point out that it doesn't seem to have any effect on the market for the copyright owner. But we don't even need to go through those because I have a de minimis defense in that, and it just so happens to be behind my head. There is also a secret, hidden fifth factor to the test, which doesn't get talked about a lot, which is, are you a bad guy? And this is kind of a weird test, but again, a weird element to the test, and it's, again, a hidden element to the test. But if you end up in court, because this is a balancing test, it can often be unpredictable how a judge is going to rule, because this test, these factors are very open to interpretation, and it's really up to how the judge feels that day, how they want to balance them out. And as often happens with balancing tests, judges are human, just like everybody else, and they are their emotions, their reactions, their personal feelings towards a defendant who is claiming fair use, those are going to factor in. So if you seem to have done your due diligence and have tried to operate within the bounds of fair use, and you're you're not a creep and you're not a criminal, then a judge is going to be more likely to accept your argument for why your use of a underlying copyrighted material is fair use. And they will look at sort of external things that aren't necessarily supposed to factor into the fair use doctrine under the legislative test, but will worm their way into the balancing nonetheless. And so if you're just an independent publisher who maybe made an honest mistake, they're more likely to weigh that in your factor, as opposed to if you are a giant mega global corporation who seems to be kind of playing fast and loose and sort of using the fair use doctrine as a way to get around copyright limitations that will factor in. Oh, yes, sure.
There was a question by Bill Ward Brickpile saying, this is going back to your example of the poster.
Sure.
Does talking about the poster change it to a different use, in this case as education?
Yeah, that's a really good question. So there's kind of two uses there, right? The first is it's just as decoration in the background on this stream. So that's one use, and that would definitely be a de minimis defense there. Now, great point about me bringing it up actively and moving out of the way so you can see the entire thing. In that case, yes, I am using that to make an educational point. And so in that case, you could actually look at that use as a separate use from it just being in the background. In this case, I am showing it. I'm reproducing it digitally, which by streaming it, which I'm gonna go into that in a little bit of how the practicalities of just the digital age and the internet and things like streaming and blogs and Twitter, how that shows that maybe our copyright regime and our fair use doctrine needs a little bit of updating to make it a little bit clearer. But to go directly to the question, is that I would say that's a separate use, using it there. But in that case, question is, let's go down the four factors. Purpose and character of the use. Obviously, I'm using that as an example, so it's educational. I am adding something on top of it. It is transformative because I'm talking about the legal implications of displaying it. Nature of the copyrighted work. Obviously, it's fictional. It's a photograph that was created by a photographer and then turned into a poster by a graphic designer, and it's obviously published. So those factors balance in either direction, but don't really seem to obviate the use of fair use there. Amount and substantiality of the portion taken. Obviously, I'm showing the entire poster, although there is an element where it'd be very difficult, right, to make any money, to sell this or copy this or anything from the stream, right? It's not very high quality. There's a glare on it. So even though you're seeing the whole poster, it's not like it's a high quality 100% reproduction of it. And then on the fourth factor, we have effect of the use upon the potential market. I severely doubt that that this would affect the market for Rosemary's Baby posters. Although I guess it could, but I highly doubt that. And you also need to look at the new / potential market for copyrighted work. Is there potentially a market for streaming, for backgrounds for streaming? Absolutely, there absolutely is. There are markets that there are websites you can go to license copyrighted posters or backgrounds, things like that, artwork for streaming. So maybe that element, that sub element of that factor would weigh against me in fair use. But I think that, again, overall, we're looking at this holistically, looking at those factors. Most of those factors seem to weigh pretty heavily in terms of fair use for me. And so I wouldn't be too concerned about Paramount Pictures who I assume still owns the copyright, that Paramount Pictures would not be able to sue me and either enjoin me from using this poster in the background or levy statutory damages against me for these. But great question. So when in doubt, what can you do to protect yourself in terms of making sure that you're using fair use? Obviously, you want to balance these factors over and over and over again. You know, come back to them, look at them, figure out how they apply to your particular situation. But there are ways to avoid the entire fair use discussion anyway. One way is to use properties where copyright or trademark doesn't apply. So obviously, public domain images are not subject to copyright, and therefore you can use them however you'd like. And there is no copyright holder who can sue you in court for that. What public domain actually is a little bit beyond the scope of what we're talking about here, but certainly watch that IP and licensing panel from earlier today. I believe they do mention public domain in that. You can also acquire permission or a license from the copyright holder in order to use it. If you are, what I've found is that normally, if you're going to use an underlying copyrighted work in a way that would be covered by fair use anyway, it's very easy to get permission from the copyright holder to do so. So that is often just a very good best practice to employ, even if you have a fairly strong case for fair use. Makes it much easier. You never have to go to court in that case. A license is similar to permission, except that normally you pay for a license or you give something else of value in order to acquire the license. You'll often see that in movies where if there's like a biopic, for instance, and it's about a musician, the filmmakers will license the music that they're famous for so that they can play it in the movie. If they don't do that, obviously you get into issues where I believe there was a Jimi Hendrix movie that was about Jimi Hendrix, and they didn't need you don't need to pay to use the actual factual events of a dead person's life, but you end up in a bad situation if they're famous. They're a famous entertainer, and you can't use any of their songs or written materials, and you end up with a movie that has a bunch of just to say a bunch of less good or less entertaining sound-alikes for their music. Another thing you can do is you can limit your search for underlying materials to Creative Commons. So there are plenty of services for that. You have Pixabay, you have Pexels. You can do a Google Creative Commons search. There are plenty of museums and libraries that keep Creative Commons databases. Wikimedia uses Creative Commons for a lot. One thing you do want to watch out for is not all Creative Commons licenses are created equal. So please be sure to abide by whatever license is made available through Creative Commons. In some a great example is sometimes you'll find people who take an image that might be available under a non-commercial creative license, and then they use it in a zine, let's say, that then they sell, that they kickstart maybe. That would be a commercial use of something that is only available under a non-commercial license. So that would be a copyright infringement even though that image was available under Creative Commons. Another license that is worth talking about in terms of RPGs is Open Gaming License, and similar, the OGL and similar things. You'll see that also with SRDs that for various systems. What those are is those are elements of games that where copyright is not is either not being claimed, or copyright is being claimed, but you and every other creator are being told that you may use these particular elements of our game and our publications. So, for instance, to go back to Dungeons and Dragons, there are plenty of terms, classes, spells, etc. that you can use, that you can talk about, that you can create media for, create products for, sell on your own website, etc. That Hasbro has said, we will let you use this. The OGL does not apply to everything that Hasbro owns. So famously, the Rust Monster, the Beholder, the Bullet, all of these monsters are essentially the property of Hasbro and Wizards of the Coast and Dungeons and Dragons. So you cannot use those. But there are things like an orc, which was not created by Hasbro. You can reproduce the stat block for an orc in your own works, because that is under the Open Gaming license. And you'll see similar licenses for Blades in the Dark. It has the Forge in the Dark license, which allows you to use a lot of the material that would otherwise be copyrighted from that book. Powered by the Apocalypse, etc. All these different licenses that exist, and generally you just want to read those licenses and make sure that you understand the terms of those licenses, and then you don't have to worry about about asserting fair use for the use of underlying copyrighted material. 7-minute warning. Okay, great. So let's go through some real quick lightning round common myths that come up where people. This is more related to general copyright, but is, I think, appropriate for talking about in the same conversation as fair use. Is it fair use if there is a lack of a copyright notice? No, it's not fair use just because there's a lack of a copyright notice. The copyright notice under U.S. law, ever since 1989, I believe, is optional. So you have moral rights in the thing that you create as an author when you create it. It does not matter that it isn't published. It does not matter that you forgot to put a little C in a circle next to it, or write copyright of me 2021 on the credits page. The copyright notice is optional. So cannot assert fair use or lack of a copyright just because there's no copyright notice. There are common myths, as I mentioned earlier, about what counts as de minimis. You've seen stuff like, if it's less than a paragraph, then it's de minimis. If it's less than 10 seconds of a song, then it's de minimis. Not true. That's a myth. You really need to either use a very, very, very small amount of it for it to be de minimis, or you need to go through those 4 factors under 17 USC 107 to determine whether fair use applies. Attribution avoids infringement. That is another myth. Just because you post on YouTube a clip from Rosemary's Baby, and you say hey, I don't own this. I'm just posting it here, but I don't own it. It's owned by Paramount. That is still copyright infringement. You may or may not be dinged for it, but that is still copyright infringement. Just because you say that you don't own it does not mean that you are allowed to use it in that way. You are still infringing the copyright of the copyright holder. That being said, you go back to our secret factor. Are you a bad guy? If you are not claiming, if you are using copyrighted material in a way that makes it obvious that you're not claiming that you own it, then that can factor in to a judge's determination of whether or not fair use applies, even though it's not necessary, even though attribution is not one of the 4 factors. Assumed value to the copyright holder. This is another myth. Sometimes you'll see this often where people repost pictures on Instagram, and they will say, this is giving them exposure. This is getting their name out there. I have 1 million followers, and people are gonna, that means 1 million impressions of people seeing this image that they made. Doesn't matter. Doesn't matter what you think the value might be to the copyright holder. What matters is what the value is to the copyright holder, or really what a judge might think is the value to the copyright holder, or what the author themselves might think is the value. Again, good way to get around this. If you think that your use is going to be something that gives value to the copyright holder themselves, then feel free to reach out to them and ask permission to use it. If they actually think that there is value in it, they will give you permission, or they will grant you a license. And if they want to charge you for it, then you can negotiate that license to avoid having to assert fair use, and you can also avoid a copyright strike. Modification does not avoid infringement, or modification avoiding infringement is another myth. The idea that, oh, well, I took this picture, but then I ran it through some Photoshop filters, and I flipped it around, and I combined it with this other thing, and now it's this new thing. Well, that does not avoid infringement, although some people think that it does, but might think that it does. Part of the reason is because you are infringing upon an additional right, which is the modification right of the copyright holder. As the creator of a thing, you have the right to determine how it is chopped up, reorganized, remixed, etc. And when somebody takes your property and they futz with it, it doesn't convert it into a non-copyright protected piece of material. So again, same principle applies. If you want to chop something up and it is not in public domain and it's not under an appropriate license like Creative Commons, then either pay for the license or gain the permission of the copyright holder. We only have a few minutes left, so I'm going to real quick go through a few wrinkles here. Trademark fair use. Fair use does apply to trademark as well, although it's slightly different because trademarks, even though they're also intellectual property, they are not copyrights. The factors for trademark fair use are there's 3 factors. There's whether the product or service in question is readily identifiable without the use of the trademark. So, for instance, one example is I can talk about how well, whether I think the New Orleans Saints are going to do well in the upcoming season. I can call them New Orleans Saints, even though that is a trademarked name, because that's really the easiest way to identify who I'm talking about. I'm talking about the New Orleans Saints. It's much easier than the whole, the football team from New Orleans or something like that. You see this a lot with people calling the Super Bowl the big game. You can call the Super Bowl the Super Bowl. That's the easiest way to identify it. Second factor there is for trademark fair use is how much of the mark are you using, and that really comes down to are you only using the portion that's reasonably necessary to identify the product or service that's being used? And again, because trademarks are, if I'm doing a educational piece about Coca-Cola, I'm going to show you the Coca-Cola logo. and that's going to be fair use of that trademark because, again, I'm using the portion that's reasonably necessary to identify the product. And third factor is whether use of the mark suggests that there's a sponsorship or endorsement of the trademark owner. So again, that comes down to just being very open about like you're just using this trademark in order to talk about the underlying product or service. You're not using it to indicate that you are being sponsored or you're somehow associated with the trademark owner. And the very last thing I want to talk about as we come up to the end here is fair use is a United States legal doctrine. It's in the United States Code. It has its roots in some English common law principles, but it really is the U.S. rule. So when we're talking about when all these principles about all these factors for fair use really only apply to if you're in the U.S. And you're dealing with United States copyright holders. That being said, outside the U.S., you will see a lot of these same principles in effect, especially for legal regimes that come out of English common law. So Anglophonic countries like the UK, Australia, etc. Outside the US, though, it's often called fair dealing, which gives specific exceptions to copyright, but they're very similar to fair use. Okay, so we're coming up on the end, but if there are any questions.
Well, I actually have a question. Since I'm in Canada, the international aspect. So if there is an issue between a Canadian grabbing something in the US or the opposite, which one is the jurisdiction that takes precedence? Is it the source of the work or where the person who does where it's being taken?
Great question. So there will basically be dual regimes. So let's say that I'm American, or I'm in the U. I'm USian. You are Canadian. If I create something and put it out there, and then you appropriate it for your own uses, then I could bring a claim against. I could bring a U.S. copyright claim against you in United States court. And there are treaties that have to do with which citizens of which countries I can bring such a claim against. Canada is one of them. There's actually an interesting wrinkle with that. If you were Australian, it's a little too fiddly for us to get into now. But I could bring a case in United States court against you for copyright infringement. And I could also potentially bring a copyright claim against you in Canada, since that would be the source. That would be the where the infringement took place. Obviously, now that we're in the digital age, those borders are much more porous than they were when we were talking about physical books and reproductions. So it would be very easy for me to make the claim that, if you took something that I published on the internet and then you started selling it yourself on the internet, it would be very easy to make the claim that you had subjected yourself to United States jurisdiction, and I would most likely sue you in U.S. court for that. But there would also be potentially liability on your part in Canada.
Cool. Thanks. Maybe wrap up.
Yeah, so I think we'll wrap up here, and once again, I'll just go through the 4 factors real quick because that's the most important part here. As long as you're not under a de minimis exception, but you want to look at, if you're deciding whether or not you have a valid fair use defense against copyright infringement, you want to look at purpose and character of the use. So how and why are you using the underlying copyrighted material? Nature of the copyrighted work. So is it factual or fictional, or is it published or unpublished? The amount and substantiality of the portion taken. So are you using more or less, or are you using the most important part? and then the effect of the use upon the potential market. So how are you affecting their ability to make money off of it either now or in the future? Okay, so with that, I think we'll bring it to a close. I want to thank Andy and Eric absolutely for their help on this panel. And just to reintroduce myself, in case you want to reach out, my name is Rob Hebert. You can find me either in the Discord for Metatopia, or you can reach me on best place to reach me is on Twitter at Nerdy Paper Games. My DMs are open, so feel free to drop a line if you have any questions or if you just want to connect. And I think that's it. Thanks, everyone.